next matter to come before the court is State versus Henkel. Good morning.
Good morning. When you
Thanks to everybody for appearing in Akron. I appreciate that. And we're ready to proceed. And you will have 15 minutes each, and you may reserve up to 5 minutes. Just let me know.
Thank you, Judge.
Thank you.
It's a motion to suppress, and the issue is very simply put whether or not the test was administered at 3 hours and whether or not the state, at the time of the motion to suppress, was able to, in fact, establish that such had occurred. The time of the that begins the clock, I guess, is 3:19. That was a time of operation that the officer put down. The facts in the case, per the brief and per the transcript, the officer observed nothing with reference to the operation. The entire case boils down to whether or not the state could show that the test was in fact administered within 3 hours. There are, one of the cases cited by the state is Rupert, and in that case there were estimates of time. In this particular case, there are absolutely no estimates of time in the record. The best case scenario is the hearsay testimony of people who had been on staff that, excuse me, my client had just entered the facility. Not that she had just driven to the facility or how long she had been outside at all. There's no indication of when the client left. There's no indication of the time when the client returned. There frankly is just nothing in the record that justifies the finding that the test was administered within 3 hours. And again, that seems to be the best case that they've got, is that she had just entered the facility, but there's absolutely no indication from the people who were outside as to, first of all, when they took their break. There's just nothing in the way of any type of realistic evidence in reference to this. The case is based upon assumptions, but assumptions need to have some correlation to what exists within the record. And there's absolutely nothing. Again,
let me just stop you for just a moment. In reading the briefs, it sounded as if the state identified the time that the call was made to the police and then worked backwards. And from that, they were able to say that the supervisor immediately called the police as soon as she was told by her staff about this situation. The staff told the supervisor immediately upon seeing her, your client, come into the parking lot. And then it sounds as if the court looked at that and said, well, you know, you've got the time of the test. If you work backwards, you've got an entire hour for all those things to have happened, and there's no way that it took an hour. Would you agree that that's the way that the court framed it?
That's the way the court phrased it, but again, there's no indication when she arrived. I mean, there just is no time on this. I mean, it really is some supposition, and again, some estimates of time. Again, I see in the case that they've got, you know, they talk about there's an estimate of time from this portion, or somebody cried for help at this point in time. I see that in their cases. But there's absolutely nothing in this record that indicates any time at all that she arrived. And that arrived is the operation. And again, as I recall, it was sort of just entered the facility. And I believe that's cited in the state's brief.
Well, obviously, we'll read the transcript in great detail, and I have not done that at this point. But it seems like from the briefs that, I don't remember the name of this, even identified that the person went out for a smoke break. And then she went back in and said that the defendant had arrived. So it doesn't, from that, it seems that they're saying like they just saw her pull in when they were outside smoking. Now, I don't know what's in the transcript, like I said, I'll have to obviously read that and see. But that seems like from your argument, you're saying, well, she could have pulled into the parking lot and sat there for 2 hours before she got out of the car.
Well, again, I don't think the weather at that particular time of year was inclement, and she was there with her son. And I think that the judge stretching it, I think it was 59 minutes, is how he would have backed it out from, I believe, 3:19 p.m. And, but again, that's another estimate. I mean, the officer writes at one point in time that the operation was at 3:30, and then indicates that it's at 3:19. But frankly, there is no absolute knowledge on that whatsoever. And again, no one knows how long she was in the parking lot.
That's what I was getting at. So your argument is she might have arrived hours before that and just sat there.
Right, because again, it's her son, and it's somebody that she visits with on a regular basis, and they're outside having a smoke. It certainly indicates to me that the weather was not inclement at that particular time of the year. And as I recall, I think it was just entered the facility. I don't know that the hearsay went to the point of, I saw her operate the motor vehicle, and then she got out and came into the facility, and then I went in and talked to you right away. Again, we have no idea when the staff was on break. Again, the primary argument of the defendant is, again, there is no reasonable or credible evidence indicating that the assumption that the court has taken would be appropriate, because that is an assumption. It is basically, it's another thing too, it's the legal argument that you have with hearsay. It's an inference on an inference. And an inference on an inference should not be used to come up with a basis to say that the test was in fact administered within 3 hours. Thank you.
Thank you.
If it'll please the court, I'm J.R. Russell, appearing on behalf of the state of Ohio in this matter. Counsel, the important thing for this court to keep in mind with this case is the standard that it applies to these cases, which is that there has to be some competent, credible evidence to support the findings of fact that this court would give due deference to, and that the trial court applied those facts in accordance with law. And in this case, there certainly was competent, credible evidence to establish the fact that the defendant in this case, at the time of the operation, defendant in this case, she admitted to Officer Schrock that she had operated the motor vehicle. There wasn't any testimony proffered by her that she had parked and walked to lunch and walked back. She admitted that there was operation of the motor vehicle. The trial court is also permitted under law to consider hearsay statements. It's not hearsay on hearsay. The declarants were the employees who were outside smoking that saw her enter the parking lot. There was no indication that she was out in the parking lot for over an hour, which would she would have had to have been out in the parking lot for greater than an hour for this test to have any danger of running outside of that 3-hour limit.
Is that what they said?
No, you go ahead.
Is that what they said, that they saw her enter the parking lot?
They saw her walking from the parking lot into the facility. So, in which case, and she admitted the operation, so she would have had to have been sitting in the parking lot for an excess of over an hour before she entered the facility with her son.
But the problem with that is, how do we know she wasn't?
Well, the trial court made, based on the evidence, the trial court made a reasonable assumption based on all the evidence that's before the court. And it's just like the case in the Rupert case and the other cases that this court has seen, is especially in case of an accident is where we see this most often. An officer can't say, I know that this operation happened at 2:15 a.m. or 6:15 a.m., but all the evidence and facts that are in the record support the finding that it could not have been longer than a period of time. And some of the cases we've seen where an officer has felt the engine and seen that the engine is still hot or the hood was still hot, or there's testimony of someone saying, well, I woke up, and especially in the Rupert case, I woke up at 6:15. I think it was 6:15 is how her testimony was. She wasn't precisely clear. But the evidence established that it couldn't have been longer than a 3-hour period, which is what we have in this case. It's uncontested that Officer Schrock arrived at the scene at 3:19 p.m. That's when he arrived at the scene. He testifies in the record that the police station is 2 or 3 blocks away from the facility, so it could not have taken him any longer than a couple minutes. We also know that Ms. Makita, she knew, because this has happened before, she knew that she would have to make the call immediately. And she testified, I called immediately. As soon as I got the report, I called the police. And so from that point, again, working backwards, Your Honor, it's clear that she could not have been in the parking lot for more than an hour, hour and a half.
Well, let me ask you this, who actually testified at that?
Ms. Makita testified. She is the one who presides over the facility. And Officer Schrock was the other witness from the state. And he established that time frame.
Well, that's what I thought, but you made it sound like that there wasn't any hearsay. So I thought you were saying that the other employees did testify.
No, there is hearsay, but he claims that there's hearsay within hearsay, which it is hearsay because the employees told Ms. Makita, and she testified, but it's not hearsay within hearsay. It is one level of hearsay. She's relaying what was informed to her, and that formed the basis of the trial court's finding, that it certainly had to be within the 3 hours because it didn't make sense to the trial court. And there was no evidence to the contrary. There was no evidence that she was out in the parking lot an extended period of time.
Well, she doesn't have to prove that.
No, Your Honor, but again, when the standard is there some competent, credible evidence? All of the competent, credible evidence establishes that.
So the employees reported, and again, we'll read the transcript.
Sure.
The testimony was the employee reported that she was out for her smoke break.
The employee was out for her smoke break.
That's what I'm saying.
Yes, Your Honor.
And what happened?
And that the employees saw her arrive, and they're the ones who contacted Ms. Makita to say, we suspect that she is under the influence of alcohol. And that's when Ms. Makita contacts the police and does her further investigation. So,
Well, when you say
we know that
they
Ms.
saw her arrive, what does that mean? That's confusing. I read that in the brief to me. They saw her arrive, drive into the parking lot, as opposed to saw her alight from her car and go into the building.
And Your Honor, they don't. There's not an elaboration in the transcript of what they meant by that. They saw her physically pull in to the parking lot, or they saw her get out of the car and enter the facility. That is not clear in the transcript. But again, the trial court appropriately applied the law in this case, and there was evidence to support the finding to allow the admissibility of the breath test in the record according to statute.
But you would agree, you do have to make an inference. Because there's not direct testimony that they saw her physically drive the car into the facility.
Yes, Your Honor. Yeah, an inference has to be made. But a judge can rely on, the trial court can rely on an inference, trial court can rely on the hearsay testimony of others. Again, it's the cases, we see it all the time with accidents. Oftentimes, in an automobile accident involving an OVI, there is not the direct testimony of, I saw that car veer off into the other lane and crash into a tree. I saw that car skid off the freeway and go into a ditch. It is a passenger oftentimes calling the police saying, there's a car in the ditch, and calling the Ohio State Patrol or whatever local facility to come out and investigate. And at that point, the officer begins his investigation. And the cases have approved that the trial court can sustain the finding without that direct evidence. Otherwise, it would be impossible in case of an accident. Yes, Your Honor.
If I may, I'm seeing here on your brief that it does state that you're saying transcript page 17 lines 5 to 10. Her staff was outside on break and they saw defendant arrive in her vehicle. That's what it says in your brief. So if the transcript states that, then someone did see her arrive,
If that's the
but
transcript.
they didn't
says-
testify.
Yes, Your Honor. They didn't testify, but
They
that's,
reported to Miss Makita that they saw her drive into the parking lot of the facility.
yes, Your Honor.
Okay.
Any further questions? Thank you, Your Honor.
The most cogent part of the transcript that the prosecution has cited is on page 7 of their brief. To the second line, they came in from outside and alerted Ms. Makita in the office. There is no indication pursuant to what the judge found that they immediately came in. So we don't know how long they delayed before they came in. And then the next part, and again, I'm just looking exactly at what he's got in his brief in the quotation at page 7 again. They reported to their supervisor that defendant, quotation marks, just entered the facility, not just entered the parking lot, just entered the facility. That is not a parking lot. That is not viewing operation.
So you're responding to Judge Hensel, Judge Schaefer's question, is that correct?
Correct. Just entered the facility, again, not the parking lot, and continue on with the quote, and appears to be intoxicated and smells of alcohol. These aren't people who are standing by a car and smell alcohol or see her visibly intoxicated. These are people who are seeing her enter the facility.
Presuming that facility means the building and not just the premises upon which the building is located. And there's no elaboration in that as a transcript, is there?
No, there is not.
So we're
But I'm
inferring
gonna-
that they mean the building, not the property.
I think, and again, I haven't taken a look at Black's Law Dictionary, and I don't know the facility is in there. But I think if you just take a look at a dictionary, the facility is certainly going to mean something like this structure. It's not going to mean the parking lot that I parked in across the street and walked over here. It's going to mean this facility. A facility, I think, is a lot more than just a piece of pavement to park your car. And again, that's what the testimony is. So again, it's not there in the operation as far as any time. Any time you've got speculation, it is an inference on an inference. And as we cite the evidence rule on this, this is not sufficient in order to carry the day. Thank you, Judge.
Thank you. The court will take the matter under advisement. A written opinion will be constructed, be mailed out to each of you, and you can look on the Supreme Court website and our own website. So thank you very much.
Thank you, Judge. Good day.